Yes, my lord, that the interpretation has to be plain textual meaning and not, my lord, anything else, my lord. But I'm not reading them, my lord. They are settled propositions. I have cited judgments, my lord, which were relevant. My lord, most of them are constitution bench judgments. And only one paragraph, my lord, your lordships can permit me to read. My lord, Jayshree Lakshman Rao Patil, my lord, that reservation matter, page 781. No, it's a basic proposition, but very well articulated. I'm not reading it because otherwise I'll have to cross my time limit. But just see the highlighted part. The first and primary rule of construction is that the intention of the legislature must be found in the words used in the legislature itself. Now come to 785. Lord, kindly treat them as read. That's all. I'm citing 785. The very fact that I did not read and said that I'm not reading because your lordships are aware, I started with that, my lords. Lord, 785 is a very important, my lord, point, which was raised by my learned senior Mr. Gopal Subramaniam. Discretion, aid and advice, and the necessary implication. My lord, allow me, my lord, to my lord, spend, my lord, 10-15 minutes on this point. My lord, his argument was that the discretion is only, kindly, my lord, discretion is only provided when it is so provided either by or under the Constitution. Correct? No, that was his argument. Now, please come to para 90 at page 785. So, therefore, my lord, the argument was that wherever either by or under discretion is not conferred, discretion does not exist. Correct? My lord, that was the submission. And very well articulated, my lords. My lord, para 90. The Constitution confers certain discretionary powers expressly. Certain discretionary powers are read as implied either because of the nature of the power, the subject matter of the decisions, or the functionary exercising the power. Article 200 is an example of certain implied discretions when the fact situation under which the government is supposed to act, governor is supposed to act, so requires. Even under Article 163, there can be implied discretion not to be guided by aid and advice. This is for the reason that sometimes exercise of power under aid and advice defeats the power itself. Take example of MP, Special Police Establishment Act. Suppose the Chief Minister is facing allegation and there is a question of sanction. 197 section or section 17 PC Act or 19 PC Act. He would still, my lord, I am saying, my lord, as a constitutional principles, I am not taking an extreme one-side view. He would still require, my lord, the aid and advice of the Council of Ministers. But he can still say that, no, this is clearly a biased advice. I am not bound by it. The council may say that don't grant sanction. And none of these provisions, my lord, the distinction was sought to be drawn that they are statutory provisions. No, the provision for which under which sanction is required, PC Act or Bharatiya Nyaya Sanhita, may be statutory, but his power which he is exercising is under Constitution. Because he is the appointing authority under the Constitution, he decides whether to grant sanction or not. There is nowhere which is mentioned that this would be done in his discretion. But that is by very nature of the power an implied discretionary power. Look, kindly read it further. It is submitted that, for example, of under the Constitution, by the Constitution, there is no dispute. Under the Constitution, discretion is evident in the following. The power to summon assembly does not use the word in his discretion. However, it is recognized that in certain situations, the said power can be exercised in his discretion. He can summon the assembly, my lord, to ask for the floor test, etc. Second, the power to order a floor test does not use the word in his discretion. However, it recognizes that in certain situations, the said power can be exercised in his discretion. The power under the second proviso to Article 200 does not use the word in its discretion. However, it is recognized that in certain situations, the said power can be exercised in its discretion. Lord, the power to grant sanction against the chief minister or ministers does not, I have not already pointed out. Then 356, it doesn't say in his discretion, but the nature of the power is such. He would never get advice from the Council of Ministers that you report under 356. So, my lord, to say that it has to be either by the Constitution or under the Constitution, my lord, would be a wrong constitutional interpretation. My lord, for which, my lord, for example, my lord, MP Madhya Pradesh Assembly, my lord, Shivraj Singh Chauhan, my lord, when this issue, my lord, came, my lord, this honorable court has said that this has to be done as per the discretion of the governor. Whom to call, when to summon the legislative assembly, floor test, etc., etc. They are neither by or under the Constitution. The discretion is not by or under the Constitution. It is read as an implied power because of the very nature of the power. Then, my lord, kindly come to 95. And, my lord, this again, my lord, I have, my lord, raised a very serious concern. I will not say objection. How you selectively place the judgments before the court. This was done before the division bench in Tamil Nadu case and unfortunately repeated before your lordships. Despite my pointing out that two paras are not read before the division bench and therefore the division two-judge bench. Anyway, my lord, please see Nabam Rabia. Para 95. My lord, kindly allow me to read 95. It is submitted that it is startling that few states opposing the reference place considerable reliance on the judgment in Nabam and read numerous paragraphs of the said judgment and specifically place reliance on paragraph 147, 148, 149, 153, 154 and 155 in order to advance the argument that the governor does not have discretion while dealing with matters concerning Article 200. The said portions of the judgment were also relied upon in order to interpret Article 163, subclause 2. The reliance of the other side on the above stated paragraphs in the judgment in Nabam Rabia and the conclusions drawn therefrom is A, wholly incomplete, and B, a clear attempt to mislead this honorable court. While the above stated paragraphs of the judgment state that there is a limited area in which the governor can exercise discretion, the said judgment itself, while making the said observations from para 147 to 155, specifically at para 151 and 152 notes that as far as Article 200 is concerned, specific reference of 200, the governor can exercise the said power in his discretion. There was a similar incomplete reading before the two-judge bench in Tamil Nadu case by the petitioner. At paragraph 301 in Tamil Nadu judgment, the Honorable Court was led to commit the mistake by skipping or omitting the most relevant paragraphs in the same context. The state government is supposed to be a virtuous litigant and should avoid skipping or omitting the most relevant parts. Lord, please see 155.3. Lord, next page. Next page. 151. The important observations your lordship gets. The important observations in Justice M.M. Punchi Commission report with reference to Article 163.2 are contained in para 4.5. A relevant extract of the same is reproduced below, and thereafter please see the bold part. But the entire thing is dealt with, but for paucity of time, I am reading bold part. The governor's discretionary power are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of the chief minister, etc., etc. We are of the considered view that the inferences drawn in Justice M.M. Panchi Commission report extracted above are in consonance with the scheme of functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of the constitutional interpretation. My lord, if your lordship would, my lord, kindly note, I don't wish to read 200, specific reference to discretion, the constitution power to withhold, there is a specific reference, and the court says that we endorse this view. This was not read, and if your lordship were to read para 301 of Tamil Nadu, my lord, this is not placed before the court, and here also it was not placed. Please, sir, why are you agitated? I am making a constitutional interpretation. You are unnecessary.
You are,
No, I will not enter into this tutu meme. You are doing. I am making, my lord, a constitutional interpretation. My lord, it may not be suitable to their interpretation, my lord.
You made a
May not
statement
suit.
which is wrong.
1, 2, 4. Anyway, I am not. Correct. But in this case, I read it, saying that it was not read before the. My lord, your lordships can say on this side. My lord, I have also come to this. But my lord, just my lord, be clear on my part. When I started with this matter, my lord, I did.
We are not on.
Yes.
We are
Your
not
lordships
in
are.
practice.
Let us leave it at that. Let us leave it at that.